Welcome to Mark My Words with Cole Carlson.
Hello, everyone, and welcome back to Mark My Words with Cole Carlson, where entrepreneurs, inventors, and business owners can learn how to protect the ideas, brands, and innovations they're building. Cole's the managing attorney at Carlson IP Law in Tampa, Florida. I'm Sean O'Connor, and today we're talking about what to do if someone copies your brand. Hi, Cole.
Hey, Sean.
Again, I am here for this conversation, and the idea that someone copies your brand. I used to live in Seattle, and of course was there as Starbucks came to be, and then of course, China launches some sort of chain that, like, from across the street looks like a Starbucks, and this is ancient history now, and that's high profile, of course. But I'm wondering, how do you know? Like, how do you even find out that another business is actually copying your brand? Because we're talking about like logos and names and trademark kinds of stuff, right? Trade dress.
Absolutely. So the legal standard for trademark infringement is likelihood of confusion. It's not identical copying. So the question that needs to be asked is, would a reasonable consumer think that the other company is you or affiliated with you? So let's say, if it's a similar name in a similar industry with a similar design or same customers, then there's a high potential for infringement there. For example, there are restaurants that have similar names sometimes, using your Starbucks example, or McDonald's. McDonald's is a very popular one where names pop up that are very similar. And then all of a sudden they get a letter.
Yeah. Well, I mean, that's the thing. Those big companies, the McDonald's of the world, Coca-Cola, like, hey, that's our dynamic ribbon device you're using over there, But I'm just curious, local business owner in Tampa, how do your clients typically find out? Is it like, hey, I was traveling through Cincinnati and I saw a company that has your same, dangerously close to your same logo?
Generally, yeah, it is word of mouth. Sometimes, and this is actually a good case for when infringement occurs, you have a consumer come to you and say, hey, I had this issue, and I really need it to get it solved.
And it turns out it isn't your company.
Exactly. That's called actual confusion. And is a very, very good indicator that there is a likelihood of confusion. So when that happens, it always is a sign that you need to reach out to an attorney and figure out
a case study in confusion. But so how do they even I mean, obviously that is, we have, John Smith here who was actually confused. How similar does it need? Like, how do you even determine the similarity? Is it a judgment calls the judge? It's like, I know it when I see it kind of a thing.
There's no bright line, unfortunately. Courts look at the visual and phonetic similarity, sight, sound, meaning.
Yeah.
And generally, if there's an industry overlap, as well as the strength of your mark. And what I mean by strength of your mark, there's 4 levels, essentially. Arbitrary marks, think Apple for computers. Suggestive marks, which are a little closer to what you're actually, your goods and services are, but are still kind of out there. Descriptive marks, which what they sound like, where they are describing what's going on. And then you have generic marks, and to stick with the Apple example, if I call my company Apple Company and I'm selling apples, that would be generic. And so the stronger the mark, the higher there is a likelihood of confusion when there's a mark a different mark that has a sight or sound or meaning that is the same. And then on top of that, as I mentioned before, actual consumer confusion really does add the cherry on top. Now, the same name in different industries can exist.
Right.
So if you have, let's just use McDonald's as an example again. McDonald's in the restaurant world is very different than, let's say a McDonald's for computers or something like that. And so when the issue comes up more when there's direct competition. That's what creates a problem.
That makes sense. I mean, I think, what's an Apple computer and Apple records a famous case? I mean, I don't know if anything came of that, or if there was a compromise, or it was one of those like, hey, no one's confusing records and computers. But as we know, Apple got into the music business.
That's right. Exactly.
So interesting stuff. And I was thinking too about like when you see signs, C word spelled with the K, you know what I mean? Like
Right.
quick with a K, quick mart, or, you know.
Well, and that goes to the sound aspect of sight, sound, meaning. So if someone's just talking about it and it has the same sound to it, it's very easy for someone who's just listening to think you're talking about the other person.
Yeah, that makes sense. What happens if someone copies your brand, but you never registered a trademark?
So what happens there is they're typically harder to enforce, and you are geographically limited. Your common law rights arise from your use in commerce. You don't need to register a trademark per se, but your protection is limited to where you actually operate. So that's
you mentioned that pizza place in Florida in a previous conversation. So that's the kind of thing we're talking about here.
Yeah, exactly. And so that geographic area tends to be what gets litigated in these common law trademark cases, because, you know, there are arguments that it's limited to the city you're in. There are arguments it's limited to the county you're in, the state you're in, the region you're in. And so, you know, that's where the litigation comes from for common law trademarks, in addition to the, you know, confusion aspect of it. And so the reason you want to pursue federal registration is it gives you nationwide priority from your filing date, and registration is prima facie evidence that you have a valid mark. So it's much easier to prove and enforce when infringement occurs.
Got it. I mean, so right there is the underlying reason to register the trademark. It is going to give you that as strong a protection as you can get, right? If someone else starts using it.
Yeah, it reaches from Alaska to Hawaii.
Yeah. Puerto Rico too?
Puerto Rico too.
So let me ask you this. Should business owners reach out directly if someone copies their brand? You know, meaning like, hey, I want to talk to the president of the company. You're infringing my trademark. Or is it really like, hey, call my attorney? Are there mistakes that can be made there?
Right. So getting an attorney, I always advise it. Any direct communication between the parties themselves becomes evidence in the litigation. And attorneys tend to write things with litigation and the court in mind. When a client is dealing with a situation like this, they tend to overstate their rights or make unenforceable threats that can kind of hurt their position. So a properly structured cease and desist allows for possible early resolution without needing to escalate it to litigation. Or on the other end of things, a properly structured cease and desist will set up and tee up the litigation itself in the best way possible.
Mm-hmm. Yeah, I could imagine. You know, it's just one of those implied things. If I get a letter in the mail with, you know, an attorney's return address on it, as opposed to Joe's Pizza, I'm probably going to pay a little more attention. It's going to tell me that Joe is pretty serious, and, you know, as opposed to a call from Joe where I'm like, okay, buddy.
Yeah, I'll give you an example. I actually recently had a cease and desist that I sent out on a Thursday to the email of the allegedly infringing party, and on Friday there was a press release that they were changing their name.
Boom.
So they work.
Yeah. I like that. Can waiting, let's say you know a certain amount of time passes, and you know, dealing with a brand infringement, is that going to make it harder to protect my rights, or are there time limits, or is it just like, look, it took me that long before it came to my attention, right? So
there's a concept in the law called latches, and basically what that means is it's called latches.
Latches.
Yeah, and it means if you sleep on your rights too long, it's an equitable term that bars you from getting any sort of relief, even if your rights are valid. So let's say you knew about an infringer for 3, 4, 5 years and decided to just let them keep making money off of it, and then file suit. That silence can be interpreted as acquiescence or permission, especially if, let's say, you send a letter to them and they continue doing what they're doing anyway. So the longer they
proof that you knew.
correct, and so the longer they keep operating under that regime, the more entrenched they become, and that makes it harder and costlier to resolve.
Yeah.
And so you really want to move on it as soon as you can.
Mm-hmm. It's almost like squatters' rights. I'm thinking about, they own that land now. What?
Right, exactly. And so yeah, the longer they stay there, the harder it is to wrench them out.
Mm-hmm. Mm-hmm. What options do businesses have if another company, say, ignores the cease and desist letter, and says like, I don't care, I'm doing it anyway.
Right. So yeah, if the other company tells you to go fly a kite, there are a couple options you have. One, you can try to enter into a coexistence agreement where both parties are limited in terms of their geographic or market restrictions. That's worked occasionally, depending on the industries involved.
Mm-hmm.
Restaurants, for example, that's a good one.
Yeah.
You can agree to out-of-court mediation or arbitration to try and get a sense of where your case is from a monetary or legal standpoint. Having a third-party neutral involved can help with that, but there is cost involved because you got to pay that third-party neutral.
Sure.
Another option is if there's a domain name dispute. So, for example, if I have a trademark on XYZ and Joe Schmo has www.xyz.com, you can go through the UDRP, it's the Uniform Domain Name Resolution process, and it's fast and cheaper than court, but it is only for domains. Okay, so if they have a shop that's called xyz.com, then you have to go through the other options. And then the nuclear option, of course, is federal litigation. It's expensive, slow, but sometimes it's necessary. And so it generally takes anywhere from 2 to 3 years, depending on the dollar figure we're talking about.
Yeah.
And also depending on the court you're in. Certain courts you can get out of there in 18 months, but it is a slow process.
Yeah. I'm interested in the domain thing, the domain conflict where, and again, I have firsthand experience with this where, a new business, we were talking in an earlier episode about founders and startups, and, we're going to call our company, Joey Blowy, and then you can't get the URL.
Right.
Someone else has registered that. Now, in that context, that the online domain resolution, what happens there? Do they make an assessment and say, hey, you need to surrender this to the Joey Blowy company, or is it they've been using the URL for years and I got to do a .net or whatever, some other workaround?
So you have to have some form of enforceable rights to your name on the front end. So you have to have some sort of priority over them.
Yeah. So Joey Blowy, in my case, would have to be a trademark, registered trademark, as an example.
Well, it doesn't need to be registered per se. You just need to show that you have the rights. So like, for example, if I were to register my trademark with the state of Florida, that registration would be sufficient for me to go to the UDRP, go through the UDRP process, and get the domain name transferred back. And so what happens is they look at the petition, say, yep, you meet all the requirements, you have enforceable rights, they're using this after your priority date, you get this website, and they will force a transfer.
I see. Okay. But that priority, so it's, if they have been using that URL for 10 years prior to me coming into the space, that's not going to happen necessarily, right? They're not going to force the transfer.
Right, exactly, because they're going to have rights over you,
right.
Because they have priority.
Just from usage, not even
just when use. Right, trademarks are purely use based in terms of where those rights come from.
Okay, yeah. I mean, there's probably no one out there listening that hasn't gone and registered some domain name that they thought would be a great business idea or something. So
absolutely. Well, and the other aspect of that you do have to worry about is cyber squatting. And because that is a thing as well. If you know somebody has rights to a name and you pick up the website with the intent to profit off of it, you could be liable for cyber squatting. So prior to purchasing and attempting to sell or selling things from a URL, it is generally a good idea to talk to an attorney first as well.
Mm-hmm. Interesting. Yeah. That scenario, like, oh, this will be a, I mean, it back in the early days, I was like, oh, I'm going to buy, vodka.com or, whatever it was, right? And they're like, and there's going to be some vodka company that's going to want that. It's like, actually, no, they're going to want their brand name. But there was a lot of that in the early Wild West of the internet.
Absolutely.
Yeah.
That's what caused the cyber squatting statutes to come into place.
Yeah. Well, that's it, right? And it's always, not always, but often happens, and in speaking to attorneys, is that the law has to catch up with the market oftentimes, right? There's things happening out there in the marketplace, and, like, see also AI, like, okay, how are we regulating this, right? Or litigating or whatever.
Absolutely. One bad actor can ruin it for everybody else.
Yeah. Great talking to you. We're out of time for this episode, but as always, good to see you, and I look forward to connecting in the future.
Thanks, Sean. Talk to you soon.
Thanks for listening to Mark My Words with Cole Carlson. If you have questions about protecting your brand, trademarks, or intellectual property, visit the website carlsoniplaw.com. And don't forget, like, subscribe, maybe share a link with a friend who's in the startup business. That could be super helpful. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.